Good evening, everybody. Wishing all of you a very good and exciting World IP Day for 2024. Today, on behalf of DPIIT IPR Chair, NC Banerjee Center for IPR Studies from Nalsar University of Law, we also wish to join the celebration of World IP Day. The tagline for this year's World IP Day is Building Our Common Future with Innovation and Creativity. So now I'm just going to present to you some of the basics of IP, some of the interesting facts of IP, and how the IP landscape is changing, keeping in mind our celebration of today's auspicious day. I know there are several concurrent events happening, and there's election in several places. So I'm really thankful to all the people who could find time and join our program today. So when I when I say that, what is IP Day? Why is April 26th looked upon as a celebration for all those people who are part of this amazing world of IP? April 26th is observed annually as World IP Day. Now, this date was established by WIPO, World Intellectual Property Organization, in the year 2000, and we had our first IP Day celebration in 2001. The purpose of this was to raise an awareness on how patents, copyright, trademarks, and design actually impact our daily life, to celebrate creativity and the contribution among creators, innovators, all who are part of this IP family. Now, April 26th was chosen because it coincides with the date with the establishment of WIPO itself 30 years ago. It was in 1917 that WIPO was established in April 26th, and it was from 2001 onwards that we started celebrating World IP Day. Now, every year, WIPO decides on a theme for WIPO, for the IP Day, so that there is a concentrated effort of focus. The first theme in 2001 was creating the future today. Indeed, an amazing theme. The theme which we are celebrating today is IP and SDGs, which is Sustainable Development Goals, building our common future with innovation and creativity. With this brief introduction and understanding of World IP Day, let's have a very brief introduction on IP. IPR is a cycle. It's a cycle which, to the extent that is completed, results in the returns which you get. Now, there are various forms of IP which we will see. Every form of IP starts with an creation, followed by an application and a protection to use that protection to build a successful business. However, if you do not want to make it into a successful business, the entire purpose of IP is lost. Now, successful business doesn't always mean monetizing by selling. It could be self use, it could be licensing, it could be assignments, and so on and so forth. Now, what are the different types of IP? But before you delve into that, one should ask the very basic question. We are talking about creativity, we are talking about innovation, we are talking about technology, basically inventions and innovative, unique creations, which you're going to take effort, time, and money to protect. The first question is it worth protecting? There may be amazing creativity done or wonderful inventions which might not require protection or may not be capable of being protected. So the first question to IP professional is whatever form is it worth protecting? And hopefully the answer is going to be yes. And once you have an answer yes for that, let's look at how all you can protect it and what could be the different forms of protection. And what is this going to give you? It's going to give you a bundle of rights, okay, for your creation or your invention, which you protect for your own use and to stop non-authorized use by any third party. The most popular forms of IP still remains to be copyright, trademark, and patents, although by TRIPS classification there are other forms of IPs also which are gaining importance day by day, like geographical indications, which is there's a great focus on this area, particularly in our country now. Industrial designs, integrated circuits, trade secrets, and plant varieties. However, in a contract is not a form of IP. I always include that because without contract, none of the IPs work. So when you look at any form of IP, you should also one should also give due importance to the contracts which are involved in the various stages of them. Before we really look into the management of IP, the handling of IP, let us understand very, very briefly what each of this type of protection means. Copyright covers all kind of creative expression. It could be literature, music, cinema, drama, sound, music, songs, and also includes software codes. Trademarks are various signs which are used by products and services to distinguish themselves. Patents cover all forms of inventions and process involved in those inventions. Basically, the technology part of it. Having covered the three most popular ones or the important ones, not that the others are any less important, depending on the area of practice, let's take a look at what those means. Geographical indication, which is popularly called or pulled along as GI, covers the names of products which are indicative to the origin and well known to the consumers. Now, these are very simple. It could be Darjeeling tea, or basmati rice, or rasgulla, Pochampalli ikat fabrics. There are close to 700 registered GIs now in the Indian database. Industrial designs cover the design element. Remember, this is not technology, it's the design which appeals to the eye. Why do you like a specific car? Why do you like a specific ballpoint pen? Because of the design. Integrated circuit or ICs are the design and functionalities of various chips which are used in different electronics, primarily semiconductors. Trade secrets are all forms of confidential information and services which are of business and commercial value to an organization. Plant varieties cover the seed varieties which could be sexually reproduced. Contracts are nothing but legal bindings which are indented. to be enforced by law. So, with this brief introduction of the various form of IP, let us cover a, do a little deeper dive into the three most popular ones. But before that, you should understand, or we should give an equal importance that it is not always that you create IP. You could buy IP also. And inc- incidentally, in today's world, this business of IP is growing by leaps and bounds. When you buy, it could be a total assignment of IP, or you could just license a portion of the IP which you need for your commercial process. Now, the conflict today in most areas of research and manufacture is whether I should spend all my energy, time, and money to build something or I can acquire it from somebody. This conflict is, whether I should build or acquire or buy. Both are okay depending on your requirements. And the points which really goes into deciding them is your timeline to market, what kind of skills you have in house, what is your budget, your research cost, your development cost, who are your competitors. Will you really lose opportunity if you spend time to build it? And once you're building anything, there is always an uncertainty of success. So both models of building IP and buying or licensing IP are becoming very, very popular. See, if somebody is buying, that means somebody is selling. One needs to be very cautious about that because the moment you want to sell or monetize your intellectual asset, you are actually giving birth to a competitor in the market. So all decisions on that should be done with keeping that in mind. How much of you have control you have on the IP, what happens, how your market share changes or not. So this is the basic standings of the business of IP. Now this year, since we are looking at SDGs, I've tried to collect and collate some information about what is the IP status in SDGs globally. Now, there are 17 sustainable development goals which have been identified by the UN. Most of them have serious patent filings, except probably three of them, like, goal number six, which is, decent work and economic growth, or goal number 10, which is focused on reducing inequalities, or goal number 17, okay, which is a partnership goal. If you look at the number of patent families which are active in these areas, the maximum happens to be in goal 9, okay, which is close to 3 lakh patent families. They are not in, I'm not talking about individual patents, will be much higher. These are families for industry, innovation, and infrastructure, followed by climate action, followed by good health and well being, followed by responsible consumption and production. You can take a look at this uh, figure to understand that patent filing in the different SDG goals are increasing importance and are given focus globally. Now, these are global numbers. Having said that, let's do a little deeper dive and see that in the last 3 years, are the patents in these areas increasing? You'll find that in the last 3 years, In most of the, why most? In all of them, the numbers have more than doubled. Take a look at the graphs. In each and every SDGs, now if you like to plot innovations against the focus or relative recency, we land up with four quadrants. One, where there is just market development being happening. The other, where you have mature technologies, and then you have emerging interests. And the fourth and the most important quadrant is these are hot topics. And in that fourth quadrant of hot topics, we have primarily three of the SDG goals where a lot of patents are getting registered. They are industry, innovation, and infrastructure, the climate actions, affordable and clean energy, and we have a mature market in health and well-being, and also in sustainable cities and communities, consumption and productions, so on and so forth. Now, on your left, if you look at those circles, you'll find that in each of these goals, sustainability goals, there are several industries which have popped up, and the filings are also very high. Like if I would like to look at production, industry, production, innovation, and infrastructure, you'll find that in that the maximum focus, the maximum innovation is happening in greenhouse gas emission reductions, agricultural manufacturing, nanotechnology. I just leave you for a few seconds to look at this graph. Figure. Now, all this IP portfolio, how to manage, what to do, what are the best practices, develops with time, develops with practice. Let's try and focus on some of the do's and don'ts, which it helps you to take a meaningful decision. The first suggestion is size does matter, but quality is more important. It's not that size doesn't matter. Size does matter, but quality is more important. By that, what I mean that large size IP portfolios do have competitive advantage and higher valuation. However, one should not lose their sight over quality. A smaller portfolio with very key patents, very important areas of innovation can also sometimes outnumber larger portfolios. Now, if you do not have quality IP in your big portfolio, then your portfolio is simply a white elephant. The second suggestion is that seek multi-layer protection because we feel that single layer is usually inadequate. Now each layer needs to be unique, which can further protect, further strengthen your monopoly in the market. Now each of those unique things can be covered by multiple patents or multiple forms of IP. Another important thing to note, especially in this time where there is a serious promotion of entrepreneurship and startups, primarily for them, because big companies have an established system to take care of them. The question is, who owns the IP? Who's the real owner? So organizations need to have a system built in where the ownership of the IP lies with them. There should be well established processes. What do I mean by processes? I mean there should be in place sufficient and adequate agreements between the employee and the employer or the contractors or the suppliers who all are involved. Because when you go for funding, your business partners, your investors will want to see the entire IP portfolio ownership in the name of the business entity. And that's possible only when you start doing those things from day one. Now, when you build a portfolio, it is not, I'm doing research or whatever inventions I get, I should protect. Yes, you should. But you should focus on the market needs. Not only today's market, also the future market. And one needs to be very focused in this so that the IP portfolio which you build over the time is valuable and its value increases with time. It is just not a number game. Now, you might also build a large number of large portfolio of different forms of IP, but can you use them? In our technical terms, what we say that do you have the freedom to practice or operate your own IP? Not always. There are situations where even though you have an ownership over a patent or you own a patent, you may not have the freedom to practice it because of the existence of a third party non expired patent. So one needs to look into those and develop what we call as a freedom to operate or freedom to practice statement, have an opinion, and it is best that through this practice we avoid a situation where one of your components of the product or one of the steps which you employ in the process of manufacture is not covered by somebody else. If such a situation happens, you would have to either revoke that patent or take a license of that patent for your own business continuity, even though you have a patent or maybe multiple patents in that domain. Now, this is a very, very important criteria, more so in startup. I think this is not only in IP or startup, this is a very, very important criteria in life also. If you procrastinate, you miss an opportunity. The question is, if not now, then when? Procrastination in protection of IP can be a permanent loss, can be a deal breaker. So don't wait for somebody, the investor or the inventor, to push you, remind you that there is an immense need to protect, especially in the startup circle, where there are competing priorities on and lack of resources or limited resources. There is often a lot of procrastination I have seen when it comes to protection of IP. Now, the question is very simple. One, how to move forward. If not now, then when? So let's look quickly at the IP roadmap, how one usually grows. from defensive to offensive to strategic to leadership. Defensive is some place where you are very clear that I am not going to infringe on somebody else's IP. I take care that my business is clean, my and I'm not infringing somebody else's IP. Offensive is time when you start making money out of it, either by manufacturing or establishing a monopoly or stopping others, or even by through means of licensing and assignments. The next step is strategic, where you actually call for investments, where you show your or display your IP to get venture capital. You use it for negotiating in your business, for licensing, cross licensing, improving your liquidity, and also in case you would like to go public for your IPO offerings. The last part was most probably the leadership position, where you are like a benchmark. People follow you. Your demonstrated process of IP management is well cherished and established in the business domain. Now, this cannot happen in silos. It has to happen in a team function. So you need to have patent portfolio investigation. You need to have a constant uh, framework, and this is not something which is static. It's a dynamic process. Today, which your most valuable patent may be for the market dynamics or the emergence of other products and other patents tomorrow become useless. So this is a continuous process of evaluation, continuous process of marking your patents, and moving forward with a meaningful decision how you want to handle them, how you want to keep them, or how you want to shred them. Now, this is one of my favorite books. I took it from one of my favorite books. The name of the book is Edison in the Boardroom, which clearly articulates a pyramidal structure of IP management, where you start from defensive, cost control, profit center, then integrated, and finally your visionary. This is very similar to what I have just said in two slides back. The aim is to be defensive, where you do not infringe on anybody else's IP and move forward. Then you have a cost control, and then from a cost center, that is the center, a unit which is only spending money, you gradually become a profit center where you leverage your IP in your business to make revenue, more and more revenue. Okay, and finally, your leadership is your visionary position, where you have a very long-term strategy and you are considered as a benchmark. Now, if you look at IP management is a very, very simple game. Now, this simple game is between value and risk. And how this game needs to be played? Very simple. Maximize your value, minimize your risk. And once you can establish a system where this happens, where your value gets maximized and your risks get minimized, you are in the right path of the IP management game. How do you maximize your value? You maximize your value by maximizing your branding, your presence. And how do you minimize your risk? You minimize your risk by, having near zero violations. You don't infringe, you avoid infringing others, and you have a sustainability business model for continuity of your firm, your revenues, and all related aspects. Now, maximization of value can be done usually in four different processes. First, you need to have policies, and the policy should protect your own IP and also should respect others' IP. You need to have a compliance system, which is basically a cross-functional team overseen by senior management. Then you should have proper confidentiality processes and agreements, employer agreements, access managements, and you need to have security in your network and computer, and also physical security. How do you minimize your risk? It is through assessment and mitigation. You need to have a proper assessment of the risk and try to mitigate it. You need to have a proper training process, where there is appropriate training at every level of people involved in developing, maintaining, and handling the IP. There could be specialized training for several certain areas of individual involved in the process. You need to monitor this through all through and incorporate your experience to uh, improve as you track those improvements, take corrective actions. The word which is very popular in the corporate is called CAPA, CAPA. CAPA means corrective action and preventive action. So when you see an incident, what is the corrective actions you have taken so that the risk is mitigated? And what is the preventive action you have taken that it will not reoccur again? So now this has to be done on a regular basis, risk evaluation, depending on your business model, whether it be monthly, quarterly, or annual, where not only you look at your increase in value or decrease in risk, you also study competitive information and information inside your company, which are made available through certain disclosures. The key matrix is to benchmark. So, no governance structure works well if there is no proper supervision. So, you need to have this for IP. What are your key initiatives? Protect IP from the start, establish a plan, leverage IP to attract investment. In case you are licensing, be very cautious about the scope, term, the rights, the termination clauses, the payment and other charges. Now, this is a small table where I have put three different important parts of IP: patent, trademark, and copyright, and try to compare them. So, this is critical to establish, to understand, to conclude that your IP which you have developed should fall in which category and what steps you should be taking. Okay. Registration process is there only for patents, copyright is not required, but you need to keep proof. You, if you want to register it, registration is also there. Process is there with the copyright registrar, but it is not a mandatory requirement. Okay. Now, just hold on for a couple of seconds for you to take a look at this chart. I'm not really going to read all those and trouble you. Now, this is where the IP dynamics is changing today. Changing means, you have so many areas of technology, whether it's autonomous system or machine learning or, real term translation or virtual champions or chatbots, where the influence of AI, artificial intelligence, is increasing. Now, these areas which you see are very, very IP intense areas. The business in most of them are very, very dependent on IP. Now that these areas of are getting influenced or highly influenced by artificial intelligence, IP in those areas are also getting affected. And it calls for a fresher look. See, we are now in an era where machine systems and computers are creating and innovating in areas which were usually dominated by humans only. So machines are not only competing with us, some cases they're doing better than us. Thankfully, those machines, those systems, those codes are developed by humans only. Now let's take a look at how this AI is really influencing the IP. If you look at what is AI and how it has come, I feel we are now in the sixth wave of AI. See, AI is not something very new. Okay. It started in the mid 20th century, okay, in the Dartmouth College. It started with very, very, basic things from cybernetics. As a matter of fact, the term AI or artificial intelligence was coined to differentiate it from cybernetics. Now, that was done by a great guy, John McCarthy, in 1956 during a workshop at Dartmouth College. What it means in plain language words, it is a simulation of human intelligence in machine that are so programmed to think like humans and mimic human actions. The computer science has had a very rigid definition for that. They call it a study of intelligent agents. However, a more descriptive category would be the system's ability to correctly interpret external data, to learn from such data, use those learnings to achieve certain goals and tasks through flexible adaptation. Now, that's what AI is. Now, let's see how this is affecting IP and three and related areas, so on and so forth. See, with AI comes a lot of existential risk. Many of them may sound very theoretical today, but what I mean by existential risk is that if you use AI, these risks, sorry, are going to be there. You cannot do away with those risks. First of them is the fear of superintelligent AI. So the AI is continuously learning and improving. That's how machine learning started. So there is a fear that it might someday become superintelligent. And if it becomes superintelligent, we humans may not be in a position to control it. There could be lack of control on AI. And AI doesn't align with human values or may not align with human values. Now, so there could be, because it learns from the data and it could develop certain bias from the input data which has been used to generate that program. Now, if you look at geopolitical situation, using AI in strategic decisions can be fateful at times. And of course, today we have military system and weaponry which are controlled by AI, which could result in some unnecessary devastations if not taken care of. And all that can lead to economic disruption. So now, some of these have started showing their shoots, but many of them are could be looked upon as a theoretical thing now. But they are fears. They are they are in the mind of common people and will continue to be there till we find a solution for them. Now, if you look at the various levels of experts have divided AI into five different levels, including a zero level, where there's no AI. We are believed to be really functioning very well in the level one, which is the emerging level, where we have ChatGPT, Bard, Llama, Gemini, and so on and so forth. We are moving towards a competent level, which is level 2, where it's believed to have 50 percentile of the skilled adults. I don't think we have really reached there much. Then we have level 3 as expert, level 4 as virtuous, and level 5 as superhumans, which actually mimics 98th percentile, 99th percentile, and 100 percentile. But we are very, most of the developers, scientists, and researchers are ambitious that we will sometime reach that level. And with that, we are going to face some challenges. So, what are the challenges which we can face? There are some challenges which would be with security. There would be risk of jailbreaking. There will be prompt ingestion. Prompt engineering is becoming a module in most engineering or technology schools today, because how you make the right prompt so that you get the desired answers. Now, learning from limited set of data which has gone in can result in data poisoning, evasion, adverse inputs, and there could be insecure output handlings. In addition to that, this could affect privacy of the data. You don't know, it could be individual or personal data which has been used to reach a conclusion. There could be data reconstruction, that means getting data from several sources and reconstructing that data for which will again affect privacy, and because it will lead to a model, and that there could be model thefts, and sometimes there could be denial of services and escalations as we look forward. AI and legal, yes, AI and legal, we'll have to focus on data protection. We have to focus on privacy laws, IP laws, mainly on the ownerships, and which will lead, once we define ownership, which will lead to liabilities. So we need product liability laws, consumer protection laws, antitrust and competition laws. Now these are areas where most of them are very IP related. Let me tell you, we do not have sufficient provisions in any of those areas, be it data protection or product liability or IP, to handle what AI is doing today or what AI is promising to do tomorrow. So these are focus areas, these are challenges. Ethics is another area, because many a times this is not very a transparent process. It cannot be explained. So we need to increase the transparency and need to improve on the explainability. The autonomy of the system makes it again a risk. Dual use or multiple use of the data which has been input for a certain purpose can be used for multiple other purposes. Okay, there could be qualified intentions, and as I said, both bias and fairness can be developed because of input data may be limited or not very comprehensive in nature. And finally, the accountability of systems are very low, and we do not really have a process to catch them if if something goes wrong. So there are regulatory requirements as well, which is safety and certification, uh, public input. Yes, there is public has an opinion when it comes to regulatory and the accountability part. These are all autonomous systems which could have legal limitation and oversights, and there are no compliance mechanisms available right now. Okay, there's a guidelines which has come out from US and UK. Some uh, There's some law from Israel and China, some statutes. In India, we are trying to come up with something which is there now for public commenting. Some white papers are there. We are not sorted out how to handle all this. Additionally, documentation record keeping becomes important, which is a compliance requirement. This leads to several hallucinations, which could result in multiple unintended consequences. And so there are risks. Now, if there are risks or challenges, we need to set the system right. We can't avoid the system because this is risky. Even crossing the street is risky. Then, we fix it up. So there's a lot to be fixed up here. Lots to be fixed up here. Before we can really cross the road without much tension. And the main areas which needs can be fixed are mainly accountability, because uh, there should be an adherence to guidelines, whether it is ethical, legal, or best practices. Systems should be accountable. Then there are requirements on ethical grounds, so that there is a certain amount of fairness which is observed, and misuses are reduced. Explainability, yes, very critical to build up trust and acceptance. Responsible, yes, because if there are consequences, which could be both positive and negative, the responsibility factor becomes of utmost importance. Transparent, yes, both users and stakeholders must feel that the system is not only reliable and accountable, but also fair, which is possible to assess if the system is transparent. And finally, it has to be trustworthy. See, overall reliability, credibility, fine. Not it has to be trustworthy, so that there is a widespread adoption. So these are the principles which needs to be addressed, focused, and deliberated, so that we finally can cross the road with minimum tension. What's there for us in the future? Okay, we have artificial intelligence, which is machine learning, robotics, vision, natural language processing, and so forth, which would someday also believe to mimic cognitive functions of humans, both physical and the mind. We are also moving forward from there. Life is not getting stuck there. We're moving to adaptive and augmented intelligence. Adaptive is when there is uh, the training of the AI with a specific domain knowledge, which makes it a to produce better and more accurate outputs. One step forward would be augmented intelligence, where not only there is domain knowledge, there's also a great deal of learning and clinical knowledge, all in a single platform, to process them and come out with more and more meaningful suggestions and outputs. Finally, if you want to put IP into all that and find, we need to have a specific risk and compliance management of IP to handle AI. And some of the suggested practices are to have a proper IP management system, which should be cross functional, establish visibility in all practices, carry out proper due diligence. Is it? And not only in the practices, there should be visibility on potential problems also, which includes all co creators, partners, and suppliers, build in preventive practices, which could be addressed to some extent by following best practices and providing sufficient training, responding to violations, And if there's a violation, there is no need to hide it under the carpet. Let's bring it out, address it, and follow a corrective and preventive steps as and when that may be necessary. So IP management is not just it's not a strategy, it's not a statement, it's not a fad. It is crucial for any organization who is working with proprietary technology. If you are a generic player or dealing with Me Too products, your requirement may be low, but still there. But if you are dealing with proprietary technologies, proprietary process, it is absolutely imperative that you cannot move your focus out of IP management if you want a sustainable business, business continuity, and technological advancement. With that, I would like to again wish all of you the best wishes once again for World IP Day. Have a nice time. Have a nice evening. Thank you very much. Uh, I don't know if we have questions. We can take some of the questions. Yeah. Do we have some questions? Yeah, I think there is. Yeah, this we'll take one or two before we officially close this. Yeah, I can. Somebody's asking about deep fake. Yes, deep fake is indeed a problem. Indeed, a problem in all spheres. See, deep fake is a union of two words. Deep fake is a union of deep technology and fake. Now, this was first coined by an anonymous user in Reddit who, who took the facial images of uh, two or three celebrities and pasted them in some other indecent images, and he gave the term deep fake. Now, these are uh, possible using AI, these are possible using technologies. We do not really have a control on them. This is not only ethical violation, this is a lot of IP violations, all that. Is there another question? Let me check if there's another question. Yes, there is another question which said that what are some of the most critical IP due diligence practices uh, that should be observed by entrepreneurs? Well, there are a lot of practices. First is, as I said, clear your ownership, start protecting from the beginning, do a proper due diligence, do a proper valuation. If you are not in a position to do them properly or adequately, there are experts available who can help you on those at the startup level. Hmm. There are big companies also who do that for a living. Let's see. Okay, this is a very, very tricky question. What trends or changes do you foresee in patent law over the years? There is definitely going to be a lot of changes, primarily because, see, law is a follower, technology is the forerunner. So, with advancement of technology, with advancement of uh, the new and newer emerging technologies coming in, the laws would need to be amended to take care of them, especially in IP. Right now, there is some, the main object is again ownership and liability, which is coming up. We do not have a statute in every jurisdiction to really address them. In most jurisdictions, one point is come up over and over again. That is, a machine or cannot be an inventor in a patent. But what if a program writes a poem or a story? Can he, who will be the copyright owner? These are certain areas which are still debated. Clarity is emerging gradually and slowly. But maybe we'll take one more question, which is IP created using AI based programs legally protectable? Yes, of course. See, there are protection criteria. If they fulfill, they are protectable. The debate comes is that on primarily on who's going to be the inventor, who's going to be the copyright owner. These are also defined under the various acts. So if you so there is some hurdle to cross, some bumps on the roads, but the answer to that in a very broad manner will be both yes and no. If you can justify the protectionable grounds, it is. And again, if you want a machine to be the copyright owner or to be the inventor, well, these are nowhere in the horizon. There are a couple of more questions, but I think we will end it now. So, ladies and gentlemen, thank you for joining us today on this World IP Day. With this note, I will end today's session. We'll surely have much more events and much more intense programs, including multiple experts in the days to come. So, stay tuned in. Have a wonderful evening. Thank you very much. We can stop streaming.